Welcome to Employment Law This Week. I'm George Whipple. The Supreme Court wrapped its term on July 1st. This was the first term with a new balance of power tipped by President Trump's third High Court appointee, Amy Coney Barrett. Epstein, Becker, Green's Stuart Gerson is here to talk about recent decisions and upcoming cases that could change things for employers.
The final case decided by the Supreme Court in this term that had anything to do with employment was the Cedar Point Nursery case. And that is where the court held with a strict division between liberals and conservatives prevailing, that a California statute that required employers in a farm setting to allow union organizers on their property for up to 120 days a year constituted a regulatory taking under the 14th Amendment of the Constitution. That certainly is a case that's going to affect labor organizing in the future, and it's one that employers need to pay attention to. A case that employers will take heart from, and which is going to affect cases in the future, is the case of TransUnion against Ramirez. Now, that's not an employment case. That's a class action case. And of course, employers increasingly find that they are subject to class actions in a whole bunch of areas, from strict employment law to cybersecurity. In the Ramirez case, a 5-4 majority of the court substantially cut back on a class where at least 2/3 of it were not economically cognizably injured in a way that would support jurisdiction under Article 3 of the Constitution. It would seem that under Article 3 of the Constitution, an individual, whether a class member or otherwise, needs to come to court with an injury in fact that can be redressed by the lawsuit. And in many, if not most, of these modern type of class actions, that's not the case. And the Ramirez case stands for a point that will be beneficial to employers and others who are frequent subjects of class action litigation. There's little question that the single most important case decided by the Supreme Court in the just concluded term was the case of California versus Texas, which upheld the Affordable Care Act. Of course, that has ramifications for employers that are obvious. One that's slightly less obvious is a cert petition that has been granted in a case involving the CVS pharmacy company, which is going to determine whether the ACA incorporates other federal enforcement mechanisms in anti-discrimination statutes that will allow disparate impact analysis. That will be a significant case that the Supreme Court will decide. The court has shown an interest in ERISA cases. In the just decided term, the court held that an Arkansas pharmacy reimbursement law was not preempted by ERISA, cutting back on what many pension plans, employer-sponsored plans, had hoped was going to be the case. The Hughes and Northwestern case is going to involve the extent to which fiduciary breaches under the statute are preempted. And so that's another area that shows the continuing interest of the court in pension-related cases.
Thanks, Stuart, and thank you very much for watching. We'll see you next time.